of corrupt practices and non-compliance of the Electoral Act 2022 and the plea of estoppel in relation thereto, as well as the issue relating to competence of the relief sought in this petition, are matters on which the parties have joined issues in the main petition, the merits of which will be decided after considering the pleadings and evidence laid in it. It is the settled position of law that a court should not comment on or decide at preliminary stage matters or issues which are supposed to be decided in the substantive case. See Nwanko and others versus Eraduan. Ocholi on Onojo James, LCN versus INEC, citations on the record. Hence, while leaving those issues to be dealt with on the merits of the petition, we shall determine at this stage the objections relating to the petitioner's lawful standi, the non-joinder of necessary parties, and the objection to the competence of the petitioner's replies, the respondent's replies, quote some paragraphs of the petitioner's replies. Lack of lawful standi of the first petitioner. The second and third respondents and the fourth respondents in their motion filed on the 8th of May 2023 also objected to the first petitioner's lawful standi to bring this petition. The principal contention is that the first petitioner was in contravention of section 77 sub 3 of the Electoral Act 2022. They argued that the first petitioner, who was a member of the People's Democratic Party and who was screened as one of its aspirants for the presidential election, only resigned his membership of that party on the 24th of May 2022 to join the second petitioner on the 27th of May 2022. They contended that as at 30th of April 2022, the first petitioner could not have been in the register of members of the second petitioner, which it submitted to the first respondent 30 days before the presidential primary election, as mandated by section 77 sub 3 of the Electoral Act 2022. And since the first petitioner is not in the membership register submitted by the first respondent to the first respondent by the second petitioner, the first petitioner lacks the lawful standi to challenge the outcome of the presidential election. Per contra, the petitioners submitted that the issue of membership of a political party is a domestic affair of the political party concerned, and the court lacks the jurisdiction to entertain. They relied on the cases that are reproducible. The courts have consistently held in a plethora of cases that the issue of membership of a political party is an internal affair of the political party. It is not a justiciable issue, and courts have no jurisdiction to interfere. Say Enang versus Asuquo and others, Sani and Galadima and Tumbido versus INEC, citations on the record, as well as all the cases cited above by the petitioner. The provision of section 77 sub 3 of the Electoral Act 2022, which only mandates every political party to submit the register of its members 30 days before its party primaries, cannot be invoked by the respondents for the purpose of challenging the first petitioner's membership of the second petitioner. It is only the second petitioner that has the sole prerogative of determining who are its members. And having sponsored the first petitioner as its candidate for the presidential election, the first petitioner has satisfied the requirement of being a member of the second petitioner as provided for in section 131 sub C of the 1999 Constitution. It is not within the rights of the second and third respondents and the fourth respondent to question the first petitioner's membership of the second petitioner. This ground of objection is hereby overlooked. No joinder of necessary parties. The first respondent in his motion of 19th of April 2023 and the second and third respondents, as well as the fourth respondent, raised the issue of non-joinder of Abubakar Atiku or the People's Democratic Party, who came second in the presidential election as respondents to the petition. The contention of the respondent then is that since by relief 1 Roman 3, 4 Roman 4 the petition, the petitioners who came third in the presidential election are seeking to be declared the winners of the election. The petition cannot be effectually and completely determined without the joinder of Abubakar Atiku or the People's Democratic Party, who came second in the election, as respondents to the petition. For that reason, the respondents have contended that this court lacks the jurisdiction to entertain the petition as constituted. They place reliance on JJD and INEC. Buhari and Obasanjo, citations on the record. In opposition, however, the petitioners relied on the cases of Obasanjo and Eradua, Buhari and Yusuf, Akpoti and INEC, and contended that only statutory respondents provided in section 133 of the Electoral Act 2022 are necessary parties to the petition, and the petitioners are not under any obligation to join Abubakar Atiku and the People's Democratic Party.
By Section 133 of the Electoral Act 2022, the statutory respondents in an election petition are 1. The person whose election is being complained of, and 2. The Independent National Electoral Commission, which will also be deemed to be defending the petition on behalf of its officers whose conduct is complained of. In the cases of Obasanjo and Erado and Buhari and Yusuf Supra, cited by the petitioners, the Supreme Court categorically held that only the statutory respondents stated in Section 133 of the Electoral Act are necessary parties, and that losers at an election who are not statutory respondents are not necessary parties to an election petition. By the import of Section 133 of the Electoral Act 2022, the contest in an election petition is strictly between the petitioner who challenges the outcome of the election, the person who was declared the winner of the election, and the commission that conducted and declared the outcome of the election. This means that every candidate who lost the election and who is desirous of challenging the outcome of the election is expected to file his own petition against the winner of the election, and in so doing is not required to join any other candidate who lost the election like himself. It is in furtherance of this that paragraph 50 of the first schedule to the Electoral Act 2022 requires an election tribunal or court to consolidate two or more petitions which are presented in relation to the same election or return. As rightly submitted by the petitioners, the case of Jegede and INEC cited by the first respondent is clearly not applicable to this case, since the decision in that case is that Maimala Buni was a necessary party because by the provisions of Section 183 of the 1999 Constitution, he would have ceased being a governor of Yobe State if the case made out in the petition that he could not combine the offices of governor of Yobe State and acting chairman of the All Progressive Congress is sustained. In this case, Abubakar Atiku and the People's Democratic Party, who were only runners-up in the presidential elections, are not necessary parties, as they are not statutory respondents to this petition, and the petitioners here have no obligation to join them in this petition. Again, in Buhari and Obasanjo Supra, relied upon by the respondents, the Supreme Court reconfirmed its decision in Buhari and Yusuf Supra that there is no obligation on the petitioner to make a candidate who lost an election like himself a respondent to his petition. More so, as in this case, Abubakar Atiku and the People's Democratic Party have filed a separate petition number CAPPC 05-2023, which, as mentioned in the earlier part of this volume, this court has consolidated in the petition in line with paragraph 50 of the first schedule to the Electoral Act 2022. This ground of objection to the competence of the petition is unmeritorious. It is accordingly overruled. On the arguments over the competence of the relief sought in this petition, it is my view that the relief which the court can grant in an election petition are statutory, as provided in Section 136 sub 1, sub 2, sub 3 of the Electoral Act 2022. Therefore, the determination of whether the relief sought by a petitioner are grantable can only be made after trial. Challenge to competence of the petitioner's replies. The third category of the applications of the respondents seek to strike out the petitioner's replies or some paragraphs of the replies. These are first respondent's motion filed on the 9th of May 2023 seeking 1. Order striking out the petitioner's reply to the first respondent's reply for being incompetent. 2. In the alternative, order striking out paragraphs 15, 16 Roman 1 to 7, 17 to 20, 22, 24, 25, 27 to 32, 34, 36, 37, 38, 40, and 41 of the petitioner's reply for offending the provisions of the first schedule to the Electoral Act 2022. Second and third respondents' motion filed on the 13th of May 2023 seeking for order striking out petitioner's reply of 21st April 2023 for being incompetent. 2. In the alternative, order striking out paragraphs 8 to 17, 19 to 32, 34 to 42 of the petitioner's reply for introducing new facts. Fourth respondent's motion filed on the 8th of May 2023 prays for 1. Order striking out paragraphs 15 to 32 of the petitioner's reply, the fourth respondent's reply, as well as the witness statement on oath for failure to deny the fourth respondent's allegation. 2. Order striking out paragraphs 5 Roman 1 to 9, 15 Roman 1 to 7, 16 Roman 1 to 7, 17 Roman 1 to 7, 18 Roman 1 A to H, 18 Roman 2 A to E, 18 Roman 3, 5 and 7, A to B, A and B, Roman 8 A and B, Roman 9, Roman 11, 20 to 25, A to D, 26, Roman 1 and 2, 27 to 31 of the petitioner's reply to the fourth respondent's reply for raising new issues. All the respondents challenge the competence of the petitioner's reply to their respective replies or in the alternative the paragraph thereof, which they have variously listed above. Their essential contention is that the replies or in the alternative the paragraphs thereof have either raised or introduced new facts aimed at substantially altering the grounds and reliefs in the petition, or a mere repetition or rehash of the facts contained in the petition, contrary to the provisions of section 16, paragraph 16, sub 1, A and B of the first schedule to the Electoral Act 2022. The respondents replied on several judicial authorities, which are reproduced here. In response, the petitioners have argued that they have merely reacted to the fresh/new issues raised in the replies of the respondents, which attempted to justify the grounds of non-qualification of the second and third respondents, as well as the non-compliance by the first respondent with the Electoral Act 2022. They relied on Silva and INEC, PDP versus Ezeomuka, citations on the record, and urged the court to discountenance the objections of the respondents and oppose the petitioner's replies. Now, paragraph 16, sub 1A of the first schedule to the Electoral Act 2022 provides as follows, and I quote, if a person in his reply to the election petition raises new issues or facts in defense of his case, which the petition has not dealt with, the petitioner shall be entitled to file in the registry within 5 days from the receipt of the respondent's reply, a petitioner's reply in answer to the new issues of fact. So, however, that A, the petitioner shall not at this stage be entitled to bring in new facts, grounds or prayers tending to amend or add to the contents of the petition filed by him, unquote. By the import of paragraph 16 sub 1A of the first schedule, the petitioner may, in filing a reply, respond to allegations of new facts raised in a respondent's reply to the petition, provided he does not in so doing amend or add to the petition. It is instructive to observe that the words used in paragraph 16 1A are, quote, new facts, grounds or prayers tending to amend or add to the contents of the petition, unquote. The word new suggests something which is not there, while the word amend signifies modification. Add, on the other hand, means to increase. What the provision envisages, therefore, is that the reply of a petitioner must strictly be confined to the new facts raised in the respondent's reply and must not go over that to attempt to amend or add to the petition. See All Progressive Congress versus People's Democratic Party, Njadi and Wamako, Adepoju versus Awodu Yilemi, and Ikoro versus Izunaso, citations on the record. Indeed, in succinctly explaining the new issue which should attract the reply, the Supreme Court had held in Ejesimba versus Onuzuriki as follows, and I quote, a new issue to attract a reply must in law be really new in the sense of being brand and fresh. The issue must be really new to the statement of claim, in that it was not existing therein and was therefore brought into existence or introduced for the first time in the statement of defense by the defendant. The new issue, in both its contents and materiality, must be further and additional to the statement of claim. Thus, the mere fact that a defendant states his own side of the case does not necessarily make it new, particularly when the plaintiff has told a contrary story in his statement of claim. In such a situation, the case stated by the defendant amounts to joining issues with the plaintiff, and that does not bear the name of a new issue in law. A new issue arises where the plaintiff did not avert to or touch the contents of the defendant's averments in anticipation, and the defendant's averment was introduced to the pleadings for the first time and therefore unique and novel to his pleadings, unquote. A careful examination of the petitioner's petition, the first, the second and third, and the fourth respondents' respective replies, and the replies which the petitioners filed in response thereof, reveals that apart from rehashing what they have already averred in their petition and denying what the respondents have stated in their respective replies, the petitioners also introduced new facts in their replies to the respondents' replies which were not contained in their petition. This is in clear contravention of paragraph 16 sub 1A of the first schedule to the Electoral Act 2023. Paragraph 16, 1 to, The law as encapsulated in paragraph 16(1)(a) of the first schedule to the Electoral Act quoted above forbids new additions or amendments by a petitioner which are not contained in the petition, because such new additions or amendments will prejudice the respondents and breach the respondents' fundamental right to fair hearing, guaranteed by Section 36(5) of the Constitution of the Federal Republic of Nigeria, 1999, since the respondents will have no opportunity to respond to those new issues, additions, or amendments. See PDP and another versus INEC and others. Maku and another versus Al Makura and other citations on the record. An examination of the paragraph 4, Roman 3, Roman 4, and Roman 5 of the first respondent's reply shows that the paragraphs has not raised any new issue contrary to the assertion of the petitioners. In paragraph 15 of their reply, the first respondent's reply to the petition, it is only a response to paragraph 7 and 8 of the petition. But the petitioner's argument in the same paragraph 15 that the first respondents' officials at the polling units failed to give clear copies of the results of the election from ECHA to the petitioner's agents, as the clean copies given by the petitioner's agents were very faint and unreliable, is a new fact which tends to amend the petition. Paragraph 16, Roman 1 to 7, 17, second part of 18, 22, 24 of the first respondent's reply are traverse of paragraphs 21 to 27 of the petition. Hence, paragraph 16 of the petitioner's reply, which purport to respond to new issues in paragraphs 17, 18, 19, 20, 21, 22, and 24 of the first respondent's reply, actually contain new facts, which will amount to amendment of the petition. Also, paragraphs 17, 18, 19, 24, 25, 27, 28, 29, 30, 31, 32, 34, 35, 36, and 37 of the petitioner's reply to the first respondent's reply are either a rehash of the facts already averred in the petition or contain new facts which will amount to amendment of the petition. In respect of the petitioner's reply to the second and third respondent's reply to the petition, the latter are seeking for an order striking out paragraphs 8 to 42 of the petitioner's reply. However, a careful examination of those paragraphs shows that only paragraph 21 of that reply has raised a new allegation against the first respondent of attempts to manipulate the data uploaded on the back-end server of the AWS. The said paragraph 21 of the petitioner's reply to the second and third respondent's reply is hereby struck out. Similarly, the petitioners have introduced new facts in paragraphs 16, 17, 18, 20, 22, 23, 24, 25, and 27 of their reply, some of which contain serious allegations to the fourth respondents, which the fourth respondent has no opportunity to respond. Being in contravention of paragraph 16 sub 1 of the first schedule to the Electoral Act, those paragraphs are also hereby struck out. And that indeed is the rulings on the respondents' objections, various objections raised.
Well, as I was trying to explain earlier before we went for the break, we'll take all the judgments. After that, my learned brothers will now give their own decisions on the petitions in order to save time. Because the petitions are consolidated. So now we'll go to the main petition, in petition number 3. In bringing this petition, the petitioners who were contestants in the presidential elections held on 26 February 2023 have challenged the declaration return of second respondent as the winner of the election and sought for the declaration and consequential reliefs, which I have reproduced in the beginning of this judgment. The petitioners have predicated their petition on the 3 statutory grounds earlier stated. Although in the ruling of this court on the objections of the respondents, some paragraphs of petition replies have been struck out for stated reasons, this court will take into consideration the entire affirmance in the petition in determining the merit or otherwise of the petition in the interest of justice. At trial, the petitioners opened their case with tendering from the bar several certified true copies of electoral and other documents which were objected to by all the respondents, who reserved the reasons for their objections to the stage of final address. The said objections were therefore admitted, the said documents were therefore admitted and marked as exhibits without prejudice to the objections of the respondents. The court ordered the respondents to file separate addresses on their objections along with their final addresses. In proof of their petition, the petitioners called 13 witnesses who gave evidence as PW1 to PW13. Of those witnesses, only 3 had their witness statements on oath filed along with the petition, while the other 10 were subpoenaed witnesses whose statements were filed separately after hearing in the petition had commenced. The respondents objected to the competence of the subpoenaed witnesses to give evidence and adopt their addresses, witness statements on oath, and reserve the rulings for their objection to the stage of final address. Without prejudice to the objection, the said witnesses adopted their respective witnesses' statement on oath, after which they were duly cross-examined by all the senior counsel for the respondents. Upon closure of the petitioner's case, the first respondent, as well as the second and third respondents, called one witness each in their defense. The fourth respondent did not call any witness, but opted to rely on the evidence already adduced by the other respondents that elicited under cross-examination on behalf of the fourth respondent. At the close of evidence, parties filed and exchanged their respective final addresses, including separate addresses in support of their various objections, which they raised during trial. So we shall now consider respondents' objections to the competence of some of the petitioner's witnesses and to the documents tendered by them during trial. To save time, we'll skip the addresses of counsel and we'll go to the resolution of those issues. The resolution of the respondent's objections to witnesses and documents is contained in page 84 of the judgment. On the first segment of the respondent's objection, all the respondents challenge the competence of PW3, PW4, PW5, PW6, 7, 8, 9, 10, 11, and 13. And the respondent's essential contention is that the witness statements on oath whose witnesses, on oath of those witnesses of the petitioners were not front-loaded along with the petition, but were only filed during trial, contrary to paragraph 4, sub 5B of the first schedule to the Electoral Act 2022. Section 285, sub 5 of the 1999 Constitution as amended, which limits the time for presidential election petition, provides as follows. An election petition shall be filed within 21 days after the date of the declaration of the result of the elections. In the same vein, Section 132, sub 7 of the Electoral Act 2022 provides as follows. An election petition shall be filed within 21 days after the date of the declaration of the result of the elections. Paragraph 4 of the first schedule to the Electoral Act 2022 stipulates the contents of an election petition which shall be filed. In particular, paragraph 4.5 of the said schedule mandates as follows. The election petition shall be accompanied by A list of the witnesses that the petitioner intends to call in proof of the petition, B, written statements on oath of the witnesses, and C, copies or lists of every document to be relied on at the hearing of the petition. But subparagraph 6 of that paragraph, a petition which fails to comply with the above requirements shall not be accepted for filing by the Secretary. Paragraph 14, sub 2 of the same first schedule to the Electoral Act then provides as follows. After the expiration of the time limited by A, Section 132, sub 7 of this Act for presentation of the election petition, no amendment shall be made. 1. Introducing any of the requirements of paragraph 4.1 contained in the original election petition file, or 2. Effecting a substantial alteration of the ground for or the prayer in the election petition, or 3. Except anything which may be done under subparagraph 2A, Roman 2, affecting a substantial alteration of or addition to the statements of facts relied on to support the ground for or sustain the prayer in the election petition. And sub D, paragraph 12, profiling the reply, no amendment shall be made. 1. Alleging that the claim of the seat or office by the petitioner is correct or false. 2. Except anything which may be done under the provisions of paragraph 2A, Roman 2, effecting any substantial alteration to, in or addition to the admissions or the denials contained in the original reply file or to the facts set out in the reply. The above quoted provisions of the Constitution, Electoral Act 2022, and the first schedule thereto have been thoroughly considered by the Supreme Court in several cases, including Okian, another versus Mimiko and others, by Ogumbi JC, Oba and Vincent Ararume and others, and Anik, Okuru, Ogi and others, PDP and Okuru and several others listed here. In Oke and Mimiko, the apex court, par Ogumbi JC, held as follows in the court. By paragraph 4, 1 and 5 of the first schedule to the Electoral Act, a composite analysis of an election petition has been spelled out, and also a list of materials which must be accompanied. The use of the word shall in the subsections is very instructive, mandatory, conclusive. In other words, the provisions do not allow for additions, and hence, the procedure adopted by the appellants in seeking for an extension of time is nothing other than a surreptitious attempt to amend the petition. This is obvious from the nature and substance of the application, especially where one of the grounds seeks to put in facts which are allegedly not available allegedly not available at the time of filing the petition, but only came into their possession after the statutory time limit allowed for the presentation of election petition. Expressly, there is no provision in the legislation which provides for extension of time. What is more, video paragraph 14.2 of the first schedule to the Electoral Act, the appellant by section 134 sub 1 of the Electoral Act had been totally foreclosed from any amendment, which was in fact the hidden agenda promoting the application. The saying is true that even the devil does not know a man's intention. It can only be inferred from the act exhibiting that which is conceived in the heart and mind. The use of the word shall in paragraph 14 sub 2A of the first schedule to the Electoral Act is mandatory and places a complete bar on any form of amendment to a petition file and does not allow for an exercise of discretion whatsoever. Further still, on a critical perusal of the application, relief 2.6 court seek to call additional witness to which AEO. It is pertinent to state that at the close of pleadings, parties had submitted the list of witnesses who were to testify together with their depositions. The idea, purpose, and intention of the application is suggestive of nothing more but a clear confirmation seeking for an order of an amendment as rightly and ingeniously thought out by the trial tribunal and also affirmed by the lower court. This will certainly violate the provisions section 285(5) of the Constitution and section 134 of the Electoral Act, close of court. In his concurrent judgment in the same case, Nguta, JSC, specifically stated as follows, I quote, the additional or further witness depositions sought to be allowed for a just and fair determination of the petition are fresh facts as found by the tribunal, and which finding was endorsed by the lower court. This court will not interfere with a concurrent finding of fact of the two lower courts when the appellants have failed to show a special circumstance for this court to do so. Election petitions are time-bound, and the court will not allow a party to resort to any sort of subterfuge or to frustrate the intention of the Electoral Act that petitions be disposed of expeditiously. The petitioners in this case have relied on the earlier decisions of this court in Omidiran versus Ete and Lasun versus Awoyemi Supra to argue that the subpoena witnesses whose witness statements on oath were filed outside the time limited for the presentation of the petition are competent to testify because they are subpoena witnesses who do not work for the petitioners. However, it is pertinent to observe that unlike in the present case, the subpoenas issued at the instance of petitioner in the case of Omidiran and Ete and Lasun versus Awoyomi were decided under the Electoral Act of 2006, which did not have provisions similar to paragraph 4 sub 5 of the first schedule to the External Electoral Act 2022. Secondly, the subpoenas in the above two cases were issued and served on adversaries, namely the resident electoral commissioners. Again, those two cases were decided before the introduction of Section 285, subsection 6 of the 19th Constitution of Federal Republic of Nigeria 1999, which mandates that an election petition shall be decided within 180 days from the date of filing of the petition. Thus, whilst this court in Omidiran and Ete and Lasun versus Awoyemi appeared to have adopted a flexible approach, the Apex Court had taken a strict approach in its latter decision in Oke and Mimiko. Indeed, in subsequent following the Apex Court's decision in Oke and Mimiko, this court, per Agim JCA, as he then was, now JSC, highlighted this strict position of the law in Ogba versus Vincent at paragraph 46 to 48, paragraphs A to B, wherein he held as follows, I quote, I think that this court in Omidiran and Ete and the Supreme Court in Oke and Mimiko adopted different approaches in addressing the issue of whether a tribunal or court can allow a witness deposition or other document not filed along with the petition or not filed within the time allowed for filing election petition to be filed and used in an election petition proceeding. Omidiran's case did not strictly enforce the time limits prescribed in Section 141 of the Electoral Act 2006. The provision in the first schedule thereto on prohibiting the introduction of additional facts in the proceedings after the period allowed for filing the petition and closure of pleadings, and paragraph 1 sub 1 of the Election Tribunal and Court Practice Directions of 2006 on the content and form of the petition. It held that the purpose of the practice direction is to guide and regulate compliance with and observance of the provisions of the first schedule to the Act and the Federal High Court rules where applicable. This elastic application of the electoral laws by this court in that case is not in line with the current judicial approach of strict enforcement of electoral laws and the current approach of applying the Electoral Tribunal and Court Practice Directions as overriding the rules of court in election court cases. In Oke and Mimiko, the Supreme Court approached the issue in keeping with the current judicial trend of strictly applying electoral laws and procedural rules and giving them supremacy over rules of court in election cases. The Supreme Court has consistently, in a long line of cases, insisted on this strict and inelastic approach in enforcing the electoral laws. The law has laid out strict juries in Oke and Mimiko is that a witness deposition that is not filed along with the petition within the 21 days allowed for filing the petition cannot be filed in the proceedings. It held thus, if there was an evidence which was fundamental to the determination of the petition, that evidence ought to have been placed willy-nilly before the tribunal within the time limit specified by the Electoral Act or any other act. That evidence ought to be regarded as the spinal cord of the petition. Even if it has been withheld by any person, there are several ways to go about placing them before the tribunal. The Evidence Act is very clear on this. The petitioners ought to have restored to that procedure, close of court. The firm position of the Supreme Court, as stated in Okia Mimiko and followed by this court in Oba and Vincent Supra, is that by the combined provisions of Section 285(5) of the 1999 Constitution, Section 137, Subsection 7 of the Electoral Act 2022, and paragraph 4, 5, and 6 and 14.2 of the first schedule to the Act, every written statement on oath of the witness which a party intends to call must be filed along with the petition within the time limited by Section 285(5) of the Constitution of the Federal Republic of Nigeria as amended, and Section 132, Subsection 7 of the Electoral Act 2022. Once the time limited for filing of a petition has elapsed, the contents of the petition cannot be added to or amended in any manner or under any guise. Any written statement on oath of a witness filed outside that 21 days limitation will amount to a surreptitious amendment of the petition and a breach of paragraph 14 of the first schedule to the Electoral Act 2022. This is irrespective of whether the witnesses to be called are ordinary or expert witnesses and whether they are willing or supine witnesses. Since then, this has been the consistent position of the law followed by this court. Indeed, in Okuru versus Obe, this court stressed this position. Our learned brother Bolaji Yusuf just stated that court. From the records, PW3 and PW4 was summoned by subpoena issued by the tribunal and presented as expert witnesses. The question is whether this without more entitles the appellant to file their statements on oath outside the time set for filing a petition, or a reply to the respondent's reply in answer to the petition. Of the humble view that whether an expert witness or not, a witness remains a witness. Though the proviso to Order 3, Rule 3, Sub 1 of the Federal High Court Civil Procedure Rules 2009 made applicable to an election petition by paragraph 54 of the first schedule to the Electoral Act provides that the statements on oath of witnesses requiring subpoena from the court need not be filed at the commencement of the suit. 2. The witnesses who require subpoena or summons shall, at the instance of the party calling them, be served with civil form 1A before the filing of the statements of such witness. The application of that rule is with regard to and or subject to the provisions of the Electoral Act, not independent of the Act. Paragraph 54 reads, subject to the express provisions of this Act, the practice and procedure of the tribunal or the court in relation to an election petition shall be as nearly as possible similar to the practice and procedure of the Federal High Court in the exercise of its civil jurisdiction, and the civil procedure rules shall apply with such modifications as may be necessary to render them applicable, having regard to the provisions of this Act, as if the petitioner and the respondent were respectively the plaintiff and the defendant in an ordinary civil action. The provisions of the Electoral Act being a substantive law shall override any rule of court which is contrary to its provision. The subsidiary legislation must conform with the principal law, CNNPC and Afamfa Oil Limited. The proviso to Order 3, Rule 3.1 of the Federal High Court Rules 2009 cannot override or affect or whittle down the absolute and mandatory provisions of Section 285, Sub 5 of the Constitution of the Federal Republic of Nigeria, 1999, as amended, which stipulates that an election petition shall be filed within 21 days after the date of the declaration of the result of the elections, and paragraphs 4, Sub 1, 5, and 14.1 and 2 of the first schedule to the Electoral Act, which stipulate the content of a petition. It is therefore clear that in law, the provisions of Order 3, Rule 3.1 of the Federal High Court Civil Procedure Rule 2009 cannot provide a platform for filing and using witness statements on oath not filed within the time limit set for presentation of petition, and which time cannot be extended for any reason under any guise. The focus of our decision in Ogba and Vincent Supra was the injustice in allowing a piece of evidence not covered by the pleadings to be presented to the court when the opposing party would have no opportunity to react to it. It is my humble view that the position of the law, as can be gleaned from the section 2855 of the Constitution, paragraph 4, 14.2, and 16.1 of the first schedule to the Electoral Act, is that a petitioner cannot be allowed to file unused documents or witness statements on oath filed outside the time set for filing petition, and to which the respondents would have no opportunity to react. To do so will amount to creating an avenue which a petitioner can use or exploit to overreach the respondents. That is the stand of the Supreme Court in Oke and Mimiko, number 1 supra, followed by this court in Oba and Vincent supra, close of court. Again, in Ararume and another, and Anik and others, in which I wrote the lead judgment, therein are stated as follows. The law, therefore, is that the deposition of a witness must accompany the petition at the time of filing the petition. In other words, the written statement on oath of an intended witness must be filed along with the petition. Thus, any written deposition of a witness not filed along with the petition will not be countenanced by the court or tribunal. It therefore means that a written deposition filed by a witness not listed in the petition nor his deposition front-loaded cannot be countenanced by the court or tribunal after the expiration of the time prescribed for the filing of the petition. I think that is what the tribunal decided in this case, in line with the decision in Oba and Vincent. The combined effect of paragraph 4.5, Roman 1 and 2, 14.1 and 3 of the first schedule to the Electoral Act is that no witness can testify in chief before a tribunal if he has not deposed a written statement on oath, which must necessarily have been filed along with the petition. Close of court. From the foregoing judicial decisions, it is clear that in election petition litigation, whether the witnesses which a party intends to call are ordinary or expired witnesses, and whether they are willing or subpoena witnesses, their witness deposition must be filed along with petition before such witnesses will be competent to testify before the tribunal or court. It is instructive to observe that one of the leading senior counsel for the petitioners in this petition, Dr. Onyechi Ipiazu, SAN, was the lead counsel to the second respondent in Ararume and another versus Anik and others, wherein he successfully challenged the competence of a subpoena witness, Ama Ibom Agu, PW2, on the same ground that the witness statement on oath of the same witness was filed on 8/7/2019, long after the time limited for the filing of the petition. Therefore, the petitioners in this case were well aware of the settled legal position on subpoena witnesses in election petitions, stated by the Supreme Court and by this court. Yet they embarked on subpoenaing PW3, PW4, PW5, PW6, PW7, 8, 9, 10, 11, and 13, 10 out of their 13 witnesses, whose witness statements on oath were not front-loaded along with the petition. The petitioners have tried to argue that the said witnesses are witnesses of this court. With respect, this argument is misconceived because the subpoena in respect of those witnesses were issued upon the request of the petitioners. The applications for the issuance of the subpoenas were duly signed filed at the registry of this court by the petitioner counsel, and the requisite fees paid, including filing fees and service fees as assessed, were duly paid by them before this court approved and issued the subpoenas. Therefore, those witnesses are the petition witnesses and not witnesses of this court. Indeed, the procedure for calling of witnesses by the court is by summons as stipulated in paragraph 42, sub 1 of the first schedule to the Electoral Act 2022. By the provisions of that paragraph, the tribunal or court may summon a witness as a witness who appears to the tribunal or court to have been concerned in the election. It is clear from the provisions of that paragraph that it is a person summoned by the court suo motu in exercise of its powers under paragraph 42(1) that is a witness of the court and not a person subpoenaed at the request of a party to the case. In the instant case, PW3, who was subpoenaed at the request of the petitioners, is a staff of Channels Television who tendered exhibits PBH3 and PBH4 to 2 flash drives containing third annual consultative meeting with leaders of political parties held on 26 October 2022. An interview with Mr. Festus Okoye, National Annual Commissioner, held on 12 March 2023, respectively. PW4, a professor of mathematics who was engaged before the election by the petitioners and whom the petitioners presented as a supreme expert witness, stated under cross-examination by the first respondent that he concluded his report on the 19th of March 2023 before the petition was filed. PW5 is the staff of Arise Television, who also tendered exhibit PCG2, a flash drive showing the INEC chairman delivering an address at the Chatham House, London, UK, on the preparations for the 2023 elections in Nigeria. PW6 is the staff of African Independent Television, AIT, who tendered exhibit PCH1, a flash drive of the program Democracy Today, anchored on 22nd November 2022, wherein the INEC chairman was shown giving a brief on the preparations for the 2023 general elections. PW7, who claimed to be a cloud engineer and architect working with Amazon Web Services Incorporated, tendered exhibits PCJ3A to F, which are 6 reports of Amazon Web Services AWS Health Dashboard, which she said she downloaded from the Amazon website. Under cross-examination, however, she not only admitted that she is a member of the second petitioner. Please, let us be serious, please. This is a serious matter, it's not a laughing matter. She not only admitted that she is a member of the second petitioner, the Labour Party, but she had contested elections as a candidate for the second petitioner for House of Representatives elections, conducted along with the president elections on 25th February 2023. PW8, who claimed to be a cybersecurity expert engaged by the Labour Party on 10th March 2023, stated that he produced his preliminary report on 17th or 18th March 2023 before the petition was filed. He tendered exhibit PCK1, a metadata. PW9, a staff of Women and Child Rescue Initiative, a non-governmental organization, claimed to be an observer in the 25th February 2023 elections, but stated that the subpoena was addressed to him personally and served at his village address. PW10 claimed to be an annual ad hoc staff who acted as a supervisor. He stated under cross-examination that the subpoena was addressed to him personally and not through INEC. PW11, who is a staff in the Legal Services Department of National Information Technology Department Agency, NIDDA, stated that the subpoena was addressed to him personally instead of his organization. As for PW13, who claimed to have acted as a presiding officer in the 25th February 2023 elections, he stated that he was on a subpoena. The subpoena, which was admitted as exhibit PCR, was, however, addressed to him personally and not through INEC. It is pertinent to observe that the above 10 witnesses subpoenaed by the petitioners were all witnesses who were available to the petitioners at the time of filing the petition. They were neither subpoenaed as adversaries nor subpoenaed as official witnesses. It is therefore beyond controversy that the witness statements on oath of those witnesses filed after the time limited for presentation of the petition had lapsed are incompetent, and the same witnesses had no virus to testify in this petition. Their testimonies are embodied in their respective witness statements on oath, being incompetent are accordingly struck out. With regard to the respondents' objections to the admissibility of documents tendered by the petitioners, the first objection raised by the respondents is to exhibits tendered through PW4, as to exhibits tendered through PW4, 5, 6, 7, 8, and 8. These are exhibits PCD1, PCD2, PCD3, PCE1, PCE2, PCE3, PCE4, and PEF2, tendered through PW4. Exhibits PCG1 and PCG2, tendered through PW5. Exhibit PCH1, tendered through PW6. Exhibits PCJ1, PCJ2, PCJ3, A to F, and PCJ4, tendered through PW7 and exhibits PCK1 and PCK2 tendered through PW8. The said exhibits I have estimated them in this judgment. The respondents' essential argument is that since the subpoenaed witnesses and their witness statements on oath are incompetent, the documents tendered through those witnesses cannot be countenanced by the court. By paragraph 41(3) of the first schedule to the Electoral Act 2022, oral examination of witnesses is not allowed. Witnesses are only to adopt their respective written depositions and tender in evidence all disputed documents or other exhibits referred to in their depositions. By paragraph 5(b) of the schedule, such written depositions of the witnesses must be filed along with the petition. Since the above exhibits are documents, including expert reports, which were tendered through the subpoenaed witnesses whom we have already declared incompetent because their witness statements on oath were filed in violation of the mandatory provisions of paragraph 45(b) of the first schedule of the Electoral Act 2022, the documents admitted through them, which form part of their evidence, are inadmissible and liable to be exchanged from the record. See the case of Buhari and INEC. The petitioners have also argued that since the parties have agreed during pre-hearing session that documents properly certified by INEC will not be objected to, and the said documents were tendered from the bar pursuant to pre-hearing order of this court of 23rd May 2023, the parties are bound by the order of the court, since same has not been appealed against by the second and third respondents. However, this contention of the petitioners does not represent the position of the law. It is stated that a court is not permitted in any event to admit an act on it is stated that a court permitted to act in any event to admit an act on legally inadmissible evidence, even if such evidence had been admitted by agreement of the parties or under order of court in the course of hearing. Once such evidence is legally inadmissible, the court must reject it when giving its final judgment, even if that will amount to overruling itself by so doing. Shanu and AfriBank by Y4 JSC. Indeed, even in the case of Sani and Akwe, relied upon by the petitioners, this court at paragraph 20, paragraph B2A, restated the position of the law that even when pieces of evidence had been improperly received in evidence, the trial court as well as appellate court have the power to expunge it from the record and decide the case only on legally admissible evidence. On the objection of the respondents to the admissibility of the documents tendered as expert reports by the petitioners, which were admitted as exhibits PCD1 to PCD3, PCE1 to PCE4, PCJ2, PCJ3A to F, and PCK1, the respondent's contention is that they are caught up by the provisions of Section 83, subsection 3 of the Evidence Act 2011, having been contrived for the purpose of this petition. It is settled law that as provided in Section 83, subsection 3 of the Evidence Act 2011, and pronounced upon in several decisions of the appellate court that a document which is made by a party interested in a pending or anticipated proceeding involving a dispute as to any fact which the document tends to establish is inadmissible in evidence. Thus, in Latwaja and Ajimobi, where the Supreme Court, by Peter Odili, JSC held as follows, I quote, in respect of what is referred to as a person interested, I shall refer to the cases of Nigeria Social Insurance Trust versus Cliffco, Nigeria Limited. As regards to the phrase, a person interested, I agree with the respondent that the phrase has been examined in the case of Ivan versus Noble, where a person not interested in the outcome of an action has been described as a person who has no temptation to depart from the truth, one side or the other. A person not swayed by personal interest, but completely detached, judicial, impartial, independent. In other words, it contemplates that the person must be detached, independent, and non-participant, and really not interested which way in the context the case goes. Normally, a person who is performing an act in official capacity cannot be a person interested under Section 91, subsection 3, which is under Section 83.3. I think the phrase, a person interested, ever more so, has been quite definitely put in the case of Halton and Halton to mean a person who has pecuniary or other material interest in the result of the proceeding, a person whose interest is affected by the result of the proceedings and therefore would have no temptation to pervert the truth to serve his personal or private ends. It does not mean an interest in the sense of intellectual observation or an interest purely due to sympathy. It means an interest in the legal sense, which imposes something to be gained or lost. CPC and Ombugadu, when considering and determine who is a person interested under Section 91.3 of the Evidence and Truth of Health does. But the provision of Section 91.3 Evidence Act, a person interested is a person who has a pecuniary or other material interest and is affected by the result of the proceeding and therefore will have a temptation to pervert the truth to serve his personal or private ends. In fact, it is in its most recent decision in Oetola and another versus Anik, the Supreme Court, per Agim JSC, restated this position in the following words. The other evidence adduced by the appellant to prove their case is the expert analysis report prepared by PW1, who by his own admission is a member of the second appellant and had been a special assistant to the first appellant and was engaged by the appellants to establish the invalidity of the disputed results in Form EC8A for the 744 polling units. It testified further that I made the report as directed by the petitioners and that I am part of those who wrote the petition. By his own testimony, he established that he was not an independent expert, as he had an interest in the subject of his analysis and carried out the analysis from the conclusion that the results were invalid to justify to support the contemplated election petition. It was an analysis from an answer and not from a question. Such a report is not the product of an independent, impartial, detached, and professional analysis. He is clearly a person with the disposition or temptation to depart from the truth. The listing of the expert analysis report in the petition among the documents to be relied on to prove the petition it was made in anticipation of contemplation to be filed. The report having been made by PW1 as a person interested in the subject matter of the petition when the petition was anticipated to establish that the election result was invalid is not admissible evidence by virtue of Section 83.3 of the Evidence Act 2011 as amended. Close of court. In the instant case, PW4, who claimed to be an expert, was contracted by the petitioners before the election to carry out data analysis on the results of the presidential elections held on 25th February 2023. He even tendered his letter of engagement by second petitioner dated 20th February 2023, which was admitted as Exhibit PCF2. According to him, he produced his initial report on 19th March 2023. His report was made a day before this petition was filed, on 20th March 2023. Obviously, the report Exhibit PCD1 to PCD3 was prepared in anticipation of this petition. As for PW7, who also claimed to be an expert witness, she admitted that she was not only a member of the second petitioner, but had contested the House of Representatives election under the platform of the second petitioner, which election was conducted the same day with the presidential election on the 25th of February 2023. She also admitted that the report she presented in exhibits PCJ A to F are public information hosted by Amazon, which she downloaded from the Amazon website, and that the open access information she downloaded in her report cannot be amended by her. This shows that PW7 was clearly not the maker of the said documents. As for PW8, who claimed to be a cybersecurity expert, he stated under cross-examination by the first respondent that he was engaged by the second petitioner as an expert on 10th March 2023, and that he produced a preliminary report on 17th and 18th of March 2023, and final report, Exhibit PCK1, at the end of May 2023, while this proceeding was pending. It is therefore evident from the above that PW4, PW7, and PW8 are persons interested in the outcome of these proceedings. The reports produced by PW4 and PW8 qualify as statements made by persons interested in anticipation or during the pendency of this petition. As for PW7, she is admittedly an interested party, having been a member of and even contested election under the umbrella of the second petitioner. Her interest is further underscored by the fact that she admitted under cross-examination that she was attending court throughout the proceedings prior to her evidence. By virtue of Section 83, Sub 3 of the Evidence Act 2011, the reports tendered by those witnesses which form part of their evidence are inadmissible. In view of the foregoing, exhibits PCD1 to PCD3, PCE1 to PCE4, PCF to PCG2, PCH1, PCJ1, PCJ2, PCJ3 A to F, PCJ4, PCK1, and PCK4 tendered through the incompetent PW4, 5, 6, 7, and 8 are hereby expunged from the record of this court. The second aspect of the respondent's objection is on the ground of improper certification or authentication. On the second respondent's objection to exhibit PBP1 to PBP21, the IRF report for Adamawa State, on the ground that no certificate of authentication of those computer-generated documents was filed in compliance with Section 84 of the Evidence Act 2011. Exhibit PCB1 to PCB6, referred to by the petitioners in response to the objection, are IRF certificates of compliance for Bayelsa, Benue, Ekiti, Niger, Ogun, and River States. Adamawa State is not included in those exhibits. Exhibit PCC1 to PCC28, which include Adamawa State, are actually Beavers reports and their certificates of compliance. That of Adamawa is PCC21. In short, no certificate of compliance was produced by the first respondent in respect of exhibits PBP1 to PBP21. The blood IRF reports exhibits ECA series in respect of Adamawa State. However, since the documents were stated to have been downloaded from ANEC's IRF portal and were certified by ANEC as true copies of what they have in their IRF portal, the documents qualify as public documents within the meaning of Section 102 of the Evidence Act 2011, and the certification by ANEC authenticates those documents. Therefore, the provision of Section 84 of the Evidence Act is not applicable in this case. This is the position of the law as espoused by the Supreme Court in the case of Kubo and Dixie, where the Apex Court held that the computers from internet-generated documents printed from the website of a public institution is a public document, and only a copy of such document which is duly certified in compliance with Section 104 of the Evidence Act 2011 is admissible. For that, I've cited the dictum of the Supreme Court by Akas JSC in support. Exhibits PBP1 to PBP21, having been downloaded from ANEC report and duly certified by ANEC, are clearly admissible. As for the fourth respondent's objection to Exhibit PCG2, the flash drive tendered by PW5, staff of Arise TV, it is clear that the said witness had in paragraph 6 to 12 of his witness statement on oath not only stated that he participated in all stages of the recording, production, and packaging of the flash drive, but he had certified the process of its production as required by Section 84 of the Evidence Act. On the fourth respondent's objection to the admissibility of Exhibit X2, on the ground that the Exhibit X2 was obtained by the petitioners from the Register of Discord and not from the custodian of the original copy, we have examined Exhibit X2, which is the European Union Election Observation Mission Nigeria 2020 final report. As rightly observed by the fourth respondent, the photocopy of the document is certified by the Secretary of the Presidential Election Petition Court and not any officer of the European Union Election Observation Mission, which is the custodian of the original copy of the document. By Section 104.1 of the Evidence Act 2011, the secondary evidence of any public document is only admissible in evidence if it has been certified by a public officer having custody of the original copy of the document, who by that section may give a copy of same to any person who has a right to inspect, together with a certificate written at the foot of such copy that it is a true copy of such document or part of it, as the case may be. Under subsection 2 of that section, the public officer is enjoined to certify same by subscribing his name, official title, and date, and why he is authorized to use a seal with his seal. Clearly, the registrar of this court, who is not the custodian of the original copy of Exhibit X2, cannot validly certify that document under Section 104.1 of the Evidence Act 2011. See Omiseri and Arebashola, Emmanuel vs. Umana, where Mwezi JSC stated that the whole essence of the court's insistence on the scrupulous adherence to the certification requirements of public documents is to vouchsafe their authenticity vis-à-vis the original copies. Since Exhibit X2 has not been validly certified, it is inadmissible in evidence. Accordingly, Exhibit X2 stands expunged from the record. The third aspect of the petitioner's objection to the petitioner's document is on the ground that the petitioners failed to plead specific facts to cover the documents objected to. The said documents objected to by the respondents are exhibits. There are so many, they have been listed in this judgment. You get the judgment, you will see them. I have carefully examined the petitioner's pleadings and the documents objected to by the respondents. The petitioners have specifically averred in paragraph 101 of the petition that they will be relying on all defense respondents' electoral and all other necessary documents used for the conduct of the presidential election, including the documents which they listed as items A to CCC of that paragraph. However, election petitions are sui generis, and it is settled that for an averment in an election petition to be competent, material facts relating to complaints made therein must be pleaded. See Belgore and Ahmed, Ipiazu and Ochi. In the latter case of PDP and ANEC, the Supreme Court was categorical on this mandatory requirement of specificity in averments of election petitions when the court held as follows. On whether the affected paragraphs were rightly struck out, I have read the affected paragraphs and found that they relate to allegations of non-voting in several polling points, disruption of election, non-conclusion of election, some printing of ballot papers, falsification of election results, widespread disruption, irregularities and malpractice without providing particulars, or the polling units where the alleged malpractice took place. The lower court was therefore right when it held as follows. The paragraphs above, in my view, are too generic, vague, and lacking in any particulars, as they are not tied specifically to any particular polling unit or any particular number of people who were alleged to be disenfranchised. The fact that a party can file further particulars or deny in a reply the averment in the pleading must not be general, it must be specific as to facts. It is settled law that a petitioner's obligation to plead particulars of fraud or falsification without which the allegation is a non-starter. I have nothing to add to this statement of law as advanced above. I adopt it as mine. Close of court. That's why allegations of non-compliance and corrupt practices are made, such as in the instant petition. The polling units, wards, or other places where those irregularities and malpractices are alleged to have occurred must be specifically pleaded. The petitioners have argued that the issue of non-compliance by the first respondent to its laws, guidelines, and relevant statutes is a universal complaint because it is an infraction against the Nigerian people and the Nigerian state. However, this contention of the petitioners is not in consonance with the requirement of the law as espoused in Belgore and Ahmed, PDP and INEC. This is more so as the petitioner's allegations of non-compliance is interwoven with allegations of corrupt practice, and the same set of facts are pleaded for both. In the instant case, the petitioner tendered the following documents, which have been listed in this judgment. However, a look at the entire petition shows that no single complaint was made by the petitioners in respect of any of those states as to make those exhibits relevant to the petitioner's case. For instance, in paragraph 72, to which the petitioners referred in response to the objection, the petitioners have alleged that there was overvoting in the states of Ekiti, Oyo, Wando, Taraba, Oshun, Kano, Rivers, Borno, Katsina, Kwara, Gombe, Yobe, and Niger states. However, the petitioners failed to specify the polling units where the overvoting took place, the total number of accredited voters, the total number of votes cast, and the number of votes to be deducted from the scores of the parties. Similarly, in paragraph 73, which was also referred to by the petitioners in their response to the objection, the petitioners have averred that based on the uploaded results, the votes recorded for the second respondent did not comply with the legitimate process for computation of the result and disfavored the petitioners, and listed the states of Rivers, Lagos, Taraba, Benue, Adamawa, Imo, Bauchi, Borno, Kaduna, Plateau, and other states of federation. But the petitioners failed to state the scores improperly computed and how they were disfavored. As regards the objection to exhibits PCE1 to PCE4, said to be 18,084 and 88 blood results downloaded from IRF and contained in 4 boxes, the petitioners have contended that the petitioners' request for the petitioners to specify the 18,088 polling units to which those blood reports led is an impossibility because the results are unreadable and the details of most of the polling units are stated in the exhibits PCD1 to PCD3, the expert report tendered by PW4. This contention of the petitioners is, however, misconceived. This is because the petitioners who claim that they could not specify the polling units in the 18,088 blood results because those results are unreadable are the same persons who have stated that the said polling units have been specified in the expert report of PW4, through whom the blood results were tendered. However, PW4 stated under cross-examination that the primary source of the data he used in producing his report was the IRF portal. Did not state how he was able to determine the particular polling units and the impacted votes, accredited voters, and the number of PVCs collected. As I earlier noted, PW4's report was concluded on 19th March 2023 before the petitioners filed this petition on 20th March 2023, which means the petitioners were aware of the polling units to which their complaints relate even before they filed the petition. So their theory of impossibility, which they invented around the 18,088 blood results, is misconceived and an obvious misadventure. Again, in paragraphs 7 and 8 of the petition, the petitioners admitted that they have agents in the polling units and those agents signed and collected duplicate copies of the result sheets. Those paragraphs read as follows. Paragraph 7. The petitioner is a body corporate with perpetual succession and in sponsorship of the first petitioner, and the conduct of the election thereof, acted through its members duly appointed as agents at all stages of the election, namely at the polling units, the ward collation centers, the local government collation centers, the state collation centers, and the ultimate collation center at the federal level in Abuja. Paragraph 8. In the conduct of the election, the agents duly appointed by the petitioners performed their assigned and statutorily designated roles at the election. These roles included observing and monitoring the process of arrival of election materials where they were supplied by the first respondent, and leading to and including the process of accreditation, voting, counting of votes, and announcement of the results of the election. These agents were the election proceeded in due form upon the first respondent agents duly entering the results in the result sheets at the polling units, signed and collected duplicate copies of the result sheets. Having clearly admitted that their agents signed and collected duplicate copies of the result sheets, their contention that they are unable to determine the polling units from which the blood results emanated is untrue. In fact, this admission reinforces the need for the petitioners to specify all the polling units in respect of which they made complaints, since their agents were availed with copies of the results of the polling units. As regards the petitioner's contention that they have complied with paragraphs 4, 5C, and 41.8 of the first schedule to the Electoral Act 2022, I had earlier considered this argument of the petitioner while resolving the respondent objection to petitioner pleadings, wherein we held that the provision of paragraph 4, 5C of the first schedule to the Electoral Act 2022 only relates to the front-loading of documents to be relied upon by the petitioners as their evidence during trial. It does not obviate the mandatory requirement for pleading materials as stated in paragraph 41.1d and 2 and 41.8 of the same schedule, so as to enable the adverse party to know the exact case he is to meet and to respond to same accordingly. As I stated in my earlier ruling, the reports which the petitioner stated they had detailed the polling units was not filed along with the petition, so as to afford the respondent the opportunity to respond to same, but was merely tendered at trial, by which time the respondents had no opportunity to respond. Since the petitioners have failed to specify in the petition the polling units to which exhibits PCA1 to PCA4, the 18,088 ballot results relate, the said documents are clearly inadmissible. The said exhibits are hereby discountenanced and expunged from the record. We now go to petitioner objections to the respondent's documents. In the course of trial, the petitioner also objected to the documents tendered by the first and second and third respondents at the hearing of the 4th of July 2023. The first respondent had tendered exhibits RA1, RA2, RA3, RA4, R5, 6, and 7 through its sole witness, Dr. Lawrence Bayode, a deputy director in the ICT department of the first respondent, who gave evidence as RW1. Of those documents, the petitioners had objected to the admissibility of exhibits RA1, RA2, RA6, and RA7. Similarly, at the hearing of the 5th of July 2023, the petitioners had objected to all the documents tendered by the second and third respondents from the bar and through their sole witness, Senator Michael Opeyemi Bamidele, who testified as RW2. The petitioners had reserved their reasons for the objection to be adduced at the stage of final address. Pursuant to the order of this court, that parties should file separate addresses on their objections. The petitioners have filed separate addresses in support of their objections to the documents of the first respondent and those of the second and third respondents. The written address in support of the objection of the first respondent documents was filed on 23rd July 2023, while that in support of the objection to the second and third respondent documents was filed on 20th July 2023. In the written address in support of the petitioner's objection to the first respondent documents, Dr. Livy Uzoku, the learned senior counsel for the petitioners, essentially raised the sole issue of whether, having regard to the pre-hearing report of 23rd May 2023, paragraph 41, sub 3 of the first schedule to Electoral Act 2022 and other relevant provisions of the Act and decided cases, exhibits R8, 1, 2, 6, and 7 are inadmissible and liable to be exchanged from the evidence. Similarly, in the address in support of the objection to the second and third respondent documents, the petitioners raised the sole issue of whether, having regard to the said pre-hearing session report and paragraph 41.3 of the first schedule and decided cases, the documents tendered by the second and third respondents are inadmissible and liable to be expunged from evidence. Lanisel pointed out that Exhibit RA1 is a private document emanating from the third respondent and argued that in the absence of the narrow exceptions to the maker of the document, being the person to tender the document, the witness of the first respondent, thus RW1, cannot tender same in evidence. He relied on Main Street Bank Limited and General Steel Mills Others Limited. National Council also submitted that Exhibit RA2 is inadmissible because the first respondent cannot appropriate or appropriate at the same time, since Exhibit RA2, the first respondent is trying to deny another letter received by it from the fourth respondent on 15 July 2022, which he had also certified. Here we just go direct to the resolutions. So by virtue of the provisions of Section 102B of the Evidence Act 2011, public documents include public records kept in Nigeria of private documents. In the case of Onwuzurike and Idoziem and others, where the Supreme Court, Onogen JSC, held, as he then was, held that a private document sent to the police form part of the record and of the police and is consequently a public document within the provision of Section 109 of the Old Evidence Act, now Section 102 of the Extant Evidence Act 2011. It is also tried that a public document duly so satisfied is admissible in evidence, notwithstanding that it is not tendered by the maker. Indeed, a certified true copy of a public document can be tendered by a person who is not a party to the case. See the case of Maranro and Adebisi, Dagash and Bulama, Mustafa Shetima and others versus Al-Haji Bukar Customs. Exhibits RA1 and RA2, being in the public record of the first respondent, are public documents and are therefore admissible in evidence, having been certified by the first respondent under Section 104 of the Evidence Act 2011. On the petition objection to Exhibits RA6 and RA7, the record of proceedings of this court of 4th July 2023 shows that contrary to the assertion of the petitioners, the said Exhibits RA6 and RA7, which are the cloud trail log and certificate of compliance with Section 84 of the Evidence Act respectively, were not tendered from the bar but through RW1. Indeed, the record shows that the petitioners consented to the said document being taken as read and demonstrated. We therefore have no hesitation in discountenancing the petitioner's objection to those documents. On the whole, the petitioner's objection to Exhibits RA1, RA2, RA6, and RA7 tendered to respondents is unmeritorious. It is hereby overruled. We now go to objection to the petition objection to the second and third respondents' documents. We consider the Yes, the resolution without objection on the petition objection to exhibits RA8 and RA9. An examination of the petition shows that in paragraph 28, they have challenged the second respondent qualification to contest the election on the ground that he was fined the sum of $460,000 for an offense involving dishonesty, namely narcotics trafficking, imposed by the United States District Court, Northern District of Illinois, Eastern Division. As rightly submitted by the second and third respondents, they have countered this allegation of the petitioners in paragraph 46 to 53, and particularly pleaded in paragraph 50 that the United States of America, through its embassy in Nigeria, had by a letter dated February 4, 2003, addressed to the then Inspector General of Police, confirmed that upon their record checks of the Federal Bureau of Investigation, National Crime Investigation Center, NCIC, a centralized information center that maintains records of every criminal arrest and conviction within the United States of America. There were no record of any form of criminal arrest, warrants against the second respondent. The respondents shall found and rely upon a copy of the said letter of February 4, 2023, signed by Michael, I think it should be 2003, signed by Michael M. Bonner. Yes, the date is wrongly stated. It will be corrected. From the foregoing, it is obvious that issues were joined by the parties on the indictment alleged by the petitioners, and exhibits RA8 and RA9 are clearly relevant. As for the argument of the petitioner over the custody of the documents, exhibit RA8 is a letter of inquiry written by the Inspector General of Police to the Consulate General of the United States Embassy in Nigeria, inquiring as to whether the second respondent had any criminal record in the United States of America, while exhibit RA9 is the reply to exhibit RA8 by the United States Embassy in Nigeria. Both letters form part of the record of the Nigeria Police and are therefore public documents under Section 102B of the Evidence Act. Certification by the Nigeria Police Force is a confirmation that exhibits RA8 and RA9 are true copies of those documents which are in their custody. See, Onwuzurike and Idozem, Abaje and Koka. With regard to the petition objection to the relevance of exhibit R10, the record shows that the petitioner's challenge to the qualification of the second respondent was confined to allegations of double nomination of his running mate, the third respondent, and the alleged fine of the second respondent of the sum of $460,000 by a United States court. The educational qualifications of the second respondent were never challenged by the petitioners in this petition. It was the second and third respondents who introduced the educational qualifications of the second respondent in their reply, and the petitioners have not joined issues with the second and third respondents in their reply to the second and third respondent reply. It is right that a court of law adjudicates only on matters over which parties are in dispute. See Adedeji and Olosho and another Trade Bank PLC versus Benelux Nigeria Limited. Since there is no controversy or dispute between the parties as it relates to the second respondent educational qualifications, exhibit RA10 is not relevant to the termination of this petition. It is hereby discontinued. Our examination of exhibits RA11 to RA16, which are data pages and visa pages in the second respondent Nigerian passport, show that contrary to the assertion of the petitioners that the documents are not relevant, the petitioners have alleged in paragraph 28 to 32 of the petition that the second respondent was fined $460,000 for an offense involving dishonesty, namely narcotics trafficking, and in response to this allegation, the second and third respondents have denied same in paragraph 46 to 53 of their reply, and specifically pleaded those documents in paragraph 52 of their reply to the petition to show that the second respondent enjoyed an unrestricted right of ingress and egress to the United States of America and up till now, he still enjoys an unimpeded right of access to the United States of America. It is therefore a considered view that Exhibits RA11 and RA16 are relevant to these proceedings, and the petitioner objection to same is hereby discountenanced. As for Exhibits RA17 and RA18, the petitioner's reason for objecting to same has nothing to do with the admissibility of the documents. The second and third respondents, having raised objection to the first petition's locus standi to present the petition in paragraphs 1A to M of their reply to the petition. However, we have already considered and determined the issue of the petitioner's locus standi whilst resolving the respondents' preliminary objections. We have already resolved same in favor of the petitioners. Therefore, this objection has been overtaken by our ruling on the preliminary objection. On the petitioner contention that Exhibit RA19, the report of the committee on the location of the federal capital Nigeria, is not relevant, we have examined the pleadings and the said exhibit. It is apparent to us that while the petitioners have averred in paragraph 81 of the petition that a presidential candidate must score 25% of the votes in FCT before he can be declared and return elected, the second and third respondents have averred in paragraph 86 of their reply that the FCT does not enjoy a special status over the other states of the Federation, and that Abuja is still inhabited by Nigerians who are deemed equal to Nigerians in any other part of Nigeria, and residents of Abuja are not conferred with any privilege and advantage that is not accorded to citizens of other communities or states in Nigeria. We are therefore of the view that facts have been pleaded which renders Exhibit RA19 relevant and admissible. On the petitioner's objection to the admissibility of Exhibit RA22, we observe that the document is the same as Exhibit RA2, which we have already found to be admissible, having been certified by ANEC as a copy of document in their possession. The tender of Exhibit RA22, which is not even certified, is therefore a surplusage and is hereby discountenanced. With regard to the objection to admissibility of Exhibits RA24 and RA25, which are CTCs of pages 28 and 29 and 27 of Nigerian Tribunal newspapers, respectively. The reasons advanced for the objection of the petitioners are not legal grounds for challenging admissibility of a document. We have no hesitation in discounting the objection, contrary to the arguments of the second and third respondents' counsel that Exhibit RA27, the ECOWAS preliminary declaration, is a private document. The said document forms part of the official record of the Economic Community of West African States, ECOWAS, an official body established under the ECOWAS Treaty. An agreement made by member states of the ECOWAS community, and the treaty was signed by heads of states and government of the 16 member states. It is undoubtedly a public document within the meaning of Section 102 of the Evidence Act 2011. However, we observe that Exhibit RA27 is not certified as required by Section 104 of the Evidence Act to render same admissible. Not being so certified, Exhibit RA27 is hereby expunged from the record. As for the objection to Exhibit RA28 being the American Bar Association membership card of RW2, which was tendered by RW2 under cross-examination by the fourth respondent, it is clear to us that the document was neither pleaded nor listed or referred to in the statement of PW2. As rightly argued by the petitioners, Exhibit RA28 is inadmissible. Accordingly, it is hereby expunged from the record. Now we go to the merit of the petition. It's Having disposed of the various objections to witnesses and to some of the documents tendered in this petition, we now proceed to consider the merit of the petition. The parties filed, exchanged, and adopted their final written addresses, starting with the respondents. The respective final addresses of the first, second, and third, and fourth respondent were filed on the 14th July 2023, respectively. On the 23rd of July 2023, 20th July 2023, and 23rd July 2023, the petitioners filed 3 separate final addresses in response to the final addresses of the first, second, and third, and fourth respondents, respectively. In reaction to the petitioners' final addresses, the first, second, and third and fourth respondents filed their reply addresses on 28th July 2023, 21st July 2023, and 28th July 2023, respectively. The first respondent and the second and third respondent also filed lists of additional authorities on the 28th and 31st of July 2023, respectively. On the 1st of August 2023, the parties adopted their respective final addresses. In his adopted final written address, Land Senior Counsel for the first respondent, Abi Mahmoud SN, distilled the following 5 issues for determination. A, whether having regard to the provision of Section 131 and 137 of the Constitution of the Federal Republic of Nigeria 1999 as amended, and the evidence before the court, the second and third respondents were qualified to contest the presidential election of 25th February 2023. B, having regard to Section 47, subsection 2 and 3 of the Electoral Act 2022, paragraph 38 and 92 of the regulations and guidelines for the conduct of the elections 2022, the inability of the first respondent to transfer or transmit the results of the presidential election to the IRF portal real time amounted to non-compliance to Electoral Act, and whether such non-compliance substantially affected the outcome of the election. C, whether by the totality of evidence adduced, the petitioners have proven that the election of the second respondent was invalid by reason of corrupt practices and non-compliance with the provisions of the Electoral Act 2022. D, whether in the absence of any proof of lawful and unlawful votes to be added to the scores of the petitioners and or unlawful votes to be deducted from the second respondent's scores at the election, the petitioners have proven that the second respondent was not elected by a majority of lawful votes cast. E, whether having regard to the declared results of the election and the provision of Section 134, subsection 2B of the Constitution of the Federal Republic of Nigeria 1999 as amended, the second respondent ought to have been returned as duly elected after having scored the highest number of votes cast with 25% of the votes cast in over 2/3 of the states in the Federation. The Land Senior Advocate for the second and third respondents, Chief Wale Olanipekun, formulated the following 4 issues for determination. 1, having regard to the relevant provisions of the Constitution of the Federal Republic of Nigeria 1999 as amended, the salient provisions of the Electoral Act 2022, the judgment of the Federal High Court in FSCA BJCS 1454/2022 between Labour Party and INEC delivered on 23rd January 2023, which is Exhibit X1, as well as admissible evidence on record, whether the election of the second respondent into the office of President of the Federal Republic of Nigeria on 25th February 2023 was not in substantial compliance with the principles and the provisions of the Electoral Act 2022. 2, in view of the clear provisions of the Constitution of the Federal Republic of Nigeria 1999, the Electoral Act 2022, and plethora of judicial precedents on the criteria for qualification of candidates for election to the office of President, coupled with the unreported decision of the Supreme Court in SC/CV/501/2023, People's Democratic Party vs. Independent National Electoral Commission, INEC, delivered on 26 May 2023, Exhibit RA23, whether the second and third respondents were or are not eminently qualified to contest the presidential election of 25th February 2023. 3, upon a combined reading of sections 134 and 299, as well as other relevant sections of the Constitution of the Federal Republic of Nigeria 1999 as amended, Section 66 of the Electoral Act 2022, and other relevant statutes, whether the second respondent has not satisfied the necessary constitutional and statutory requirements to be declared winner of the presidential election of 25th February 2023 and returned as President of the Federal Republic of Nigeria. And 4, considering the constitution of petition and the task evidence adduced, whether this honorable court can accede to the reliefs being claimed by the petitioners. Prince L.O. Fabemi SN, the Senior Counsel for the fourth respondent, also nominated 4 issues for termination as follows. 1, whether having regard to the issues joined and the evidence laid on the nomination of the third respondent as vice presidential candidate of the second respondent and the annulled civil forfeiture the alleged civil forfeiture of the sum of $460,000 to the United States by order of the District Court in case number 93C4483. The petitioners have established that second respondent was not qualified to contest the presidential election held on 26 February 2023 as provided for in the Constitution of the Federal Republic of Nigeria 1999 as altered. 2, whether having regard to the relevant and admissible evidence led by the parties, the conduct of the presidential election held on 26 February 2023 election was vitiated by non-compliance that was substantial enough to have affected its outcome and justified nullification of the election as envisaged by the applicable provisions of the Electoral Act 2022. 3, whether the burden of proving that first petitioner and not second petitioner scored majority or lawful votes cast in each of at least 2/3 of all states of the Federation and the Federal Capital Territory to be declared and returned as the winner of the presidential election held on 25th February 2023 has been discharged by the petitioners. 4, whether having regard to the totality of the evidence led by the parties and the applicable law, the petitioners are entitled to succeed on any of the reliefs sought in the petition at all, or that the petition ought to be dismissed in favor of the respondents. On the part of the petitioners, their lead senior counsel, Dr. Livy Uzoku SN, distilled the following 3 issues in the petitioner's final address in response to the final address of the first and fourth respondents. 1, whether the second and third respondents are qualified to contest the presidential election by reason of the unchallenged facts and circumstances arising under Section 137, subsection 1D, 142, subsection 1 and 2 of the 1999 Constitution, Section 35 of the Electoral Act 2022 in this petition. 2, whether from the documentary evidence before the Honorable Court read and examined together with the unchallenged expert and technical evidence of the petition witnesses, the petitioners proved that the non-compliance by the first respondent with the relevant provisions of the Electoral Act 2022 and the subsidiary legislation made thereunder substantially affected the outcome of the questioned presidential election held on 25th February 2023. So in response to the second and third respondent final address, the petitioners adopted issues 1 to 3 of the issues for examination with the earlier filed on 18th May 2023 during the hearing session. These are 1, whether the second respondent at the time of the presidential election held on 25th day of February 23 was not disqualified to contest the said election by virtue of the provision Section 1371D of the Constitution of the Federal Republic of Nigeria as amended. 2, whether the third respondent at the time of the presidential election held on 25th February 2023 was qualified to contest the said election as the vice presidential candidate to the second respondent, and if answered in the negative, whether this did not invalidate the qualification of the second respondent to contest the said election. 3, whether the presidential election held on 25th February 2023, wherein the second respondent was declared and returned by the first respondent as the winner, was not invalid by reason of non-compliance with the provisions of the Electoral Act 2022 and any guidelines and regulations for the conduct of the election 2022 made pursuant to the Act. From the pleadings, the evidence adduced, and the submissions of counsel of the parties, it is a considered view that the following are the issues which will effectively determine this petition. One, whether having regard to the provisions of Section 137 of the Constitution of the Federal Republic of Nigeria 1999 as amended, Section 35 of the Electoral Act 2022, and the Evidence Acts, and the evidence before the court, the second and third respondents were qualified to contest the presidential election of 26 February 2023. Two, whether having regard to the evidence adduced by the parties, the petitioners have established that there was substantial non-compliance with the provisions of the Electoral Act 2022, and that the non-compliance substantially affected the results of the election. Three, whether from the totality of the evidence adduced, the petitioners have proven that the presidential election held on 26 February 2023 was invalid by reason of corrupt practices. 4, whether from the evidence adduced by the petitioners have established that the second respondent was not duly elected by a majority of lawful votes cast at the election. Well, as we stated earlier, we have summarized the submissions of counsel. We still no need of reading them out. The first issue is whether, having regard to the provisions of Section 137 of the Constitution of the Federal Republic of Nigeria as amended, Section 35 of the Electoral Act, and the evidence before the court, the second and third respondents were qualified to contest the presidential election of 26 February 2023. Well, I think this issue of qualification on this issue has been resolved in petition number 4. It's the same issue that has been raised here. So we stand by our resolution on this issue. The only exception is the allegation on the issue of the second allegation made by the petitioners in ground 1, which is contained in paragraphs 28 to 30 of the petition, is that the second respondent is disqualified from contesting the presidential election because they stated in paragraph 28 of the petition as follows. The petitioner further pleaded that the second respondent was also at the time of the election not qualified to contest for election to the office of president, as he was fined the sum of $460,000 for an offense involving dishonesty, namely narcotics trafficking, imposed by the United States District Court, Northern District of Illinois, Eastern Division, in case number 93C4483 between United States of America plaintiff versus funds in account of 2633226 held by First Heritage Bank in the name of Bola Tinubu. Funds in accounts 394833134, 394833396, 4650279566 held by Citibank NA in the name of Bola Tinubu or Compass Finance and Investment Company. Funds in accounts number that are held by Citibank International in the name of Bola Tinubu defendants. The petitioners have pleaded and relied on the order of the U.S. Court in Exhibit P5, which they tendered from the bar and which was subsequently identified by PW2 and PW12 in their evidence earlier summarized. The petitioners have centered their contention on the provisions of Section 137, subsection 1D of the 1999 Constitution, which reads as follows. A person shall not be qualified for election to the office of president if, D, he is under a sentence of death imposed by any competent court of law or tribunal in Nigeria, or sentence of imprisonment or fine for any offense involving dishonesty or fraud by whatever name called, or for any other offense imposed by him by any court, tribunal, or substituted by a competent court, by a competent authority for any other sentence imposed on him by such court or tribunal. A careful examination of the above provisions shows that the operative words of that paragraph of the section are sentence, imprisonment, or fine, and for any offense. Black's Law Dictionary, 6th edition, at page 1081, defines offense as, quote, a felony or a misdemeanor, a breach of the criminal laws, violation of law for which penalty is prescribed. The word offense, while sometimes used in various senses, generally implies a felony or a misdemeanor, infringing public as distinguished from mere private rights. Infringing on public. As, yes, and punishable under the criminal laws, though it may also include the violation of a criminal statute, which the remedy is merely a civil suit to recover the penalty, an act clearly prohibited by the lawful authority of the state, providing notice through public laws, close of court. Also, the Supreme Court, in the case of Abdullahi Umar and the state, held that an offense is an act which is clearly prohibited by law and which may be a crime or a civil offense. Sentence, on the other hand, has been defined by the same Black's Law Dictionary at page 1362 as follows. The judgment formally pronounced by the court or judge upon the defendant after his conviction in a criminal prosecution, imposing the punishment to be inflicted, usually in the form of a fine, incarceration, or probation. Again, this court also defined sentencing in Yakubu and the state as follows. The judicial determination of a legal sanction to be imposed on a person found guilty of an offense. It means the prescription of a particular punishment by a court to someone convicted of a crime. It is discernible from the above that the fine referred to in paragraph D of section 137(1) quoted above is one which emanates from a sentence for a criminal offense involving dishonesty or fraud. The words for imprisonment or fine also presupposes that the fine envisaged under the section is one which is imposed as an alternative to the imprisonment. In other words, the provision of section 137, subsection 1D relates to sentence of death or sentence of imprisonment or fine imposed as a result of a criminal trial and conviction. Indeed, in considering the offense that can amount to disqualification under section 1371 of the Constitution, the Supreme Court held in Action Congress versus ANIC as follows. The disqualification in section 137, subsection 1 clearly involves a deprivation of right and a presumption of guilt for embezzlement or fraud in derogation of the safeguards in section 36, subsection 1 and 5 of the Constitution. The trial and conviction by a court is the only constitutionally permitted way to prove guilt, and therefore the only ground for the imposition of criminal punishment or penalty for the criminal offenses of embezzlement or fraud. Clearly, imposition of the penalty of disqualification for embezzlement or fraud solely on the basis of an indictment for those offenses by an administrative panel of inquiry implies a presumption of guilt, contrary to section 36, subsection 5 of the Constitution of Federal Republic of Nigeria 1999, whereas conviction for offenses and imposition of penalties and punishments are matters appertaining exclusively to judicial power. See also the cases of Amechi and Anis Omuwaye versus Attorney General of Ekiti State, Abdul Karim and others versus Shinkafi. A careful perusal of P5 relied upon by the petitioners show that the case number 193 CV 04483 was in the civil docket of the U.S. District Court, Northern District of Illinois, and it was a civil forfeiture proceeding against funds in specified accounts with First Heritage Bank and Citibank NA. Exhibit N5 is actually an action in rem against the funds with First Heritage Bank and Citibank. It is not an action in personam against the second respondent. In Jonathan versus Federal Republic of Nigeria, citation supplied, the Supreme Court held inter alia that Section 17 of the Advanced Fee Fraud and Other Related Offences Act 2006 provides for the power to make an order of forfeiture without conviction or for an offense, and that an order of forfeiture under the section shall not be based on conviction for an offense under the Act or any other law. The Apex Court further held that there was no need to prove any crime in forfeiture property under Section 17 of the Advanced Fee and Other Related Offences Act. A civil forfeiture is a unique remedy which rests on the legal fiction that the property, not the owner, is the target. Therefore, it does not require conviction or even a criminal charge against the owner, as it is not a punishment, nor is it for criminal purposes. See also the cases of Lawari Furnitures and Bags Limited versus Federal Republic of Nigeria, Alison Madweke versus ESCC. From the legal definitions and judicial authorities cited above, it is clear that the sentence of imprisonment or fine for any offense involving dishonesty or fraud envisaged in Section 137, subsection 1D of the Constitution is one imposed upon a criminal trial and conviction. In the instant case, the petitioners have failed to show evidence that the second respondent was indicted or charged or arraigned, tried and convicted, and was sentenced to any term of imprisonment or fine for any particular offense. On the part of the second and third respondents, they have contended that the second respondent was never fined for any offense and has no criminal record in the United States. In proof of their assertion, they have tendered exhibits RA8 and RA9 from the bar and called RW2 to give evidence and identify the said exhibits as documents he referred to in his adopted statement on oath of 12 April 2023. In paragraph 45 to 52 of his statement on oath, RW2 has stated that the second respondent was never convicted or fined for any criminal offense in the United States as alleged by the petitioners. In particular, RW2 stated as follows in paragraph 46, 47, and 49. 46 says, in case number 93C4483 at the United States District Court, Northern State District of Illinois, Eastern Division, which was pleaded by the petitioners. 1. No criminal charge was filed against the second respondent. 2. The second respondent was not arraigned and did not take or make a plea to any count in the charge of allegations of crime. 3. The second respondent did not go through a criminal trial. 4. The second respondent was not convicted of any crime or any criminal activity. 5. No sentence of imprisonment was imposed on the second respondent. 6. No sentence of fine was imposed on the second respondent. 7. No form of sentence was imposed on the second respondent. 8. Case number 93C4483 was a civil suit in respect of which the court exercised civil jurisdiction under 18 U.S.C. 981 and 28 U.S.C. 1345 and 1355. In paragraph 47, he said, I also note that in case number 93C4483 at the United States District Court, Northern District of Illinois, Eastern Division, no impersonal criminal sentence was imposed on the second respondent. 49. the second respondent was not convicted in case number 93C4483, United States District Court, Northern District of Illinois. The United States of America, through its embassy in Nigeria, had, by a letter dated February 4, 2003, addressed to the then Inspector General of Police, confirmed that upon the record checks of the Federal Bureau of Investigations, National Crime Investigation Center, NCIC, the Centralized Information Center that maintains the record of every criminal arrest and conviction within the United States of America, there were no records of any form of criminal arrest, warrants against the second respondent. I shall rely upon a copy of the said letter of February 4, 2023, signed by Michael M. Bonner. Under cross-examination by the fourth respondent, RW2 has stated that as a practicing attorney in the United States, he knows that there cannot be a conviction unless there is an indictment. He also stated that exhibits RA8 and RA9 gave the second respondent a clean bill of health as far as criminal conviction is concerned. When cross-examined by the petitioner's counsel, RW2 has stated that the American court relied on Section 981 of the American Money Laundering Law, which is a civil, and not Section 982, which is criminal, and which the petitioner stated in their petition. He further stated that in the US, even a minor traffic infraction will be reported, so that if someone has a criminal record, the general record will show it. He added that a general search was conducted in respect of the second respondent. A look at exhibits RA8 and RA9 tendered by the second and third respondents showed that upon receipt of exhibits RA8 written by Nigeria's Inspector General of Police to the Consular General of the United States Embassy in Nigeria, inquiring of the criminal record of any of the second respondents, the U.S. Embassy had replied vide exhibit RA9 and stated as follows, quote, in relation to a letter dated February 3, 2003, reference number SR 3000/IGP SEC/ABJ/volume 24-289-87 regarding Governor Bola Ahmed Tinubu, a record check of the Federal Bureau of Investigation, National Crime Information Center, NCIC, was conducted. The results of the checks were negative for any criminal arrest records, warrants for Bola Ahmed Tinubu, DOB 29, date of birth, March 1952. For information of your department, NCIC is a centralized information center that maintains the record of every criminal arrest and conviction within the United States and its territories. Apart from the above, Section 249 of the Evidence Act 2011 has stipulated how previous criminal conviction outside Nigeria can be established. Section 249, subsection 1 and 2 provides a previous conviction in a place outside Nigeria may be proved by the production of a certificate purporting to be given under the hand of a police officer in the country where the conviction was had, containing a copy of the sentence or order and the fingerprints of the person or photographs of the fingerprints of the person so convicted, together with evidence that the fingerprints of the person so convicted are those of the defendant. 2. A certificate given under subsection 1 of this section shall be prima facie evidence of all facts set out in it, without proof that the officer purporting to sign it did in fact sign it and was empowered to do so. It is instructed to observe that when cross-examined by the fourth respondent, PW1 had admitted that there was no certificate under the hand of a police officer in the United States of America where a crime was alleged to have been committed by the second respondent. It is significant to state that this petition is a declaratory action in which the petitioners are seeking inter alia that this court declare the second and third respondents as unqualified to contest the election. The petitioners who have made the allegation have the burden to prove the allegation on the strength of their own case and not on the weakness of the respondents. See Okereke vs. Umahi, Imenike vs. PDP, Omunshore vs. Rebushola, Ucha and Elechi. The petitioners have evidently failed to establish their allegation that the second respondent is disqualified from contesting the presidential election under Section 137, subsection 1D,
of the 1999 Constitution because he was fined the sum of $460,000 by District Court, Northern District. As shown above, the order of forfeiture in Exhibit PA5, on which the petitioners have relied, does not qualify as a sentence of fine for an offense involving dishonesty or fraud within the contemplation of Section 137 sub D of the 1999 Constitution. As regards whether paragraph E of Section 137(1) should be read together with paragraph D of that subsection, the settled rule of interpretation of the Constitution or statute is that where the court is faced with two or more differing provisions over the same subject matter, the judicial attitude is to treat the special provision as overriding the general provision, on the principle that by enacting a separate provision for a part of the general class intends that the said part shall not be treated the same with the general class. See Atiku and another versus Attorney General Anambra State, Martin Croyder and others versus Major and Co. Nigeria Limited, but FMBN versus Olo. Since in both paragraph D and E of Section 137, subsection 1, a sentence for the offense of involving dishonesty is mentioned, but in paragraph E, a limitation of 10 years has been introduced, then it means in respect of the sentence for offense of dishonesty, the two paragraphs must be read together, such that for conviction and sentence for an offense involving dishonesty, it must be within a period of less than 10 years before the date of the election, in order for such a conviction and sentence to be used for disqualifying a presidential candidate from contesting the election. It is also a cardinal principle interpretation of the Constitution that relevant provisions must be read together and not disjointedly. See, Abegunde and Ondo State House of Assembly. From all the foregoing, it is clear that having regard to the provisions of Section 137 of the Constitution of Federal Republic of Nigeria 1999 as amended and the evidence laid before this court, the second respondent was not disqualified from contesting the presidential election held on 26 February 2023. In consequence, issue 1 is hereby resolved against the petitioners and in favor of the respondents. Issue 2 is whether, having regard to the evidence adduced by the parties, the petitioners has established that there was substantial non-compliance with the provisions of the Electoral Act 2022 and that the non-compliance substantially affected the results of the election. Again, we shall skip the submissions of counsel. Well, the appropriate starting point for the resolution of this issue is to first consider the objection of the first respondent to ground 2 of the petition, which they raised at preliminary stage, but which we deferred to this stage because it touches on the substance of the petition. The first respondent objection is that the petitioners are stopped from relitigating the issue contained in paragraph 2, paragraphs 33 to 79, as well as reliefs 5.1 and 2 of the petition, as is released to electronic transmission and collation of the election results in view of the subsequent judgment of the Federal High Court in suit number FHC ABS CS 1454-2022, Labour Party Independent Electoral Commission, delivered 23rd January 2023. A certified two copies of which they attached to their petition as Exhibit A, and which was later tendered in evidence at trial as Exhibit X1. The first respondent particularly referred this court to paragraph 55 and 74 of the petition and submitted that the facts alleging non-compliance with the Electoral Act, which are set out in paragraph 33 of the petition, are hinged on the same issue of electronic transmission of results, which was resolved against the second petitioner in the said suit number FHC ABJ SC 1454-2022, to
to the effect that there is no mandatory requirement for the first respondent to electronically transmit results of the election. Reliance was placed on Bambegin and others was Oriabe, Oyeroba and another was Olaopa. An examination of petitioner petition and Exhibit X1 shows that in their petition, specifically paragraph 37, 45 and 45, the petitioners have averred as follows. The petitioners aver that at the conclusion of the election and at each polling unit, the presiding officer was mandatorily required to electronically transfer the result of the polling unit directly to the collation system of the first respondent. In addition, the presiding officer was also mandatorily required to use the beavers to upload a scanned copy of the Form EC8A to the first respondent's result viewing portal, RF, in real time. 45, the petitioners aver that apart from the importance of the beavers in the capture of accreditation at polling unit in an election, the beavers is also mandatorily to be used in the process of uploading the information or data imputed into it by the first respondent's presiding officer at each polling unit, who shall, upon completion of voting and due recording and announcement of result, 1, electronically transmit the result of the polling unit directly to the collation system as prescribed by the first respondent. 2, use the beavers to upload or a scanned copy of the Form EC8A to the annual result viewing portal, RF, as prescribed by the first respondent. And 3, take the beavers and the original copy of each of the forms in tamper-evident envelope to the registration area for ward collation officer in the company of security agents. The polling agents may accompany the presiding officer to the registration areas for ward collation center. In Exhibit X1, the certified true copy of the judgment of the Federal High Court in suit number FHC ABJ CS 1454-2022 Supra, which the first respondent is contending should constitute estoppel to ground 2 of this petition. The sole question presented for determination in the originating summons is as follows. Whether, having regards to combined effect of sections 47(2), 52, 64, 65, and 62(1) and 2, and other relevant provisions of the Electoral Act 2022, the respondent can still insist on manual collation of results in the forthcoming general elections. Upon determination of the above questions, the plaintiff, which is the second petitioner herein, sought for the following reliefs. 1, a declaration that the respondent has no power to opt for manual method other than electronic method provided for by the relevant provisions of the Electoral Act. 2, an order of this honorable court directing / compelling the respondent to comply with the Electoral Act 22 on electronic transmission of results in the forthcoming general election. In its judgment in Exhibit X1, the Federal High Court held as follows. In view of the foregoing, can the act of the defendant in collecting and transferring election results manually in the forthcoming 2023 general election be said to be contrary to the relevant provisions of the Electoral Act 2022? The answer can only be in the negative, as there is nowhere in the above cited sections where the Commission or any of its agents is mandated to only use an electronic means in collecting or transferring of election results. If any, the Commission is only mandated to collect and transfer election results and number of accredited voters in a way or manner deemed by it. In view of the above, I am finding that by the provision of sections 52 and 65 of the Electoral Act 2022, the correct interpretation of said statute is that the defendant, Independent National Electoral Commission, is at liberty to prescribe the manner in which election results could be transmitted and are so whole. Consequently, this matter is hereby dismissed. Close of court. It is tried law that for a judgment of a court to constitute estoppel in a subsequent action, it must have finally decided the same issue in contention between the same parties or their previous. See Anchorage Leisures Limited and others versus Eco Bank, Nigeria Limited. And Adebayo versus Babalola and others. From the averments contained in the petitioner's petition, which I have earlier reproduced above, it is clear that the petitioner allegation of non-compliance averred in paragraph 2 of the petition is hinged on the contention that ANIC was mandatorily required to electronically transmit or transfer the results of the polling units directly to the collation system of the first respondent, and also mandatorily required to use the beavers to upload a scanned copy of the Form EC8A to the first respondent result viewing portal, IRF, in real time. First, it is evident that in both this petition and in Exhibit X1, the parties are the same. In that second petitioner herein was the sole petitioner plaintiff in Exhibit X1, while the first respondent herein was the sole defendant in Exhibit X1. Secondly, from the above referred averments in this petition and the relief sought by the petitioner in in Exhibit X1, it is clear that the issue in both cases is whether the first respondent herein is mandatorily required to electronically transmit or transfer election results from the polling unit direct to the collation system. With the judgment of the Federal High Court in Exhibit X, the excerpt of which has been reproduced above, it is evident that the Federal High Court had decided the issue against the petitioners herein by holding that the first respondent cannot be compelled to electronically transmit election results. There is no evidence before this court that the second petitioner against whom the judgment in X1 was given has appealed against that decision. It is settled law that an appealed decision of the court remains subsisting and binding on the parties. See Abba versus Abba Aji, Jegede and INEC, Alexander and others versus Lone Star Drilling Company Limited. It is also tried that the doctrine of issue established is that where an issue has been decided by a competent court, the court will not allow it to be relegated by the same or different parties. It is also pertinent for us to state that in the final address of the first respondent, our attention was drawn to the recent decision of the Lagos Division of this court in appeal number CA/LAG/332/2023, APC and Labour Party and 42 others, wherein this court set aside the decision in suit number FHC/L/CS/370/23, Labour Party and others versus ANIC. Another case, forum shopped by the second petitioner at the Lagos Division of the Federal High Court after losing at the Abuja Division of the same court in Exhibit X1. In the judgment in appeal number CALG-CV332/2023, this court had upheld the decision of the Federal High Court in Exhibit X1 and construed same against the petitioners as issue estoppel in relation to the petitioner's contention which they are making in this petition that ANIC is mandatorily required to electronically transmit election results. By virtue of Section 122, subsection 2 of the Evidence Act, this court is entitled to take judicial notice of the decision in appeal number CALG-CV332/2023, APC versus Labour Party and 42 others. Not only that, this court is by the doctrine of precedent bound by that decision. Since the above judicial pronouncements have decided that under the Electoral Act and ordinary regulation guidelines for the conduct of election, the first respondent cannot be compelled to electronically transmit election results, the petitioners are clearly stopped by those decisions from contending in ground 2 of this petition that the first respondent is mandatorily required to electronically transmit the election results to the collation system. As a court of first instance, in this petition, we shall, notwithstanding our above finding, proceed to determine the merit of ground 2 of the petition relating to non-compliance. It is observed that in their petition, the petitioners have alleged the same set of facts in paragraph 33 to 79 as constituting both non-compliance and corrupt practice. On a careful perusal of the petition, however, it seems to us that the allegations of non-compliance are contained in paragraphs 33 to 56 and 59 of the petition, while specific allegations of corrupt practice were made in paragraph 60 to 78, even though same were also founded on the same facts of non-compliance alleged by the petitioners. The gravamen of the petitioner allegations of non-compliance are as encapsulated in paragraphs 37, 45, 50, 51, and 55 of petition, which are reproduced below. I have produced. The respondents, particularly the first respondent, denied the allegations of non-compliance made by the petitioners in their respective replies to the petition. In particular, the first respondent denied that there was any collation system of the first respondent to which polling unit results were mandatorily required to be electronically transmitted or transferred directly by the presiding officer, and stated that the prescribed mode of collation of results is as stipulated in paragraph 50 to 55 of the regulations and guidelines for the conduct of elections. They further stated that the prescribed mode of collation was manual collation of the various forms EC8A, EC8B, EC8C, EC8D, and EC8E of the presidential election. See paragraph 31 of the first respondent's reply. They also stated that the BVAS is designed to upload the accreditation data at the end of the accreditation process, scan and transmit the result of the election at a polling unit through the e-transmission system, which is uploaded to the first respondent's result viewing portal, IREF. The first respondent further averred that the upload of data or images captured and automatically restored on the BVAS device requires data service, and where there is no such data service, or where the service is poor, the BVAS service is designed to work offline, and the upload of data will occur when data service is available. They also stated that polling unit results were duly uploaded on the first respondent e-transmission system by the respective presiding officers at the end of the election, but some of the results were not visible on the RF portal due to the technical glitch experienced on the election day. In specific response to the petitioner's allegation of failure, refusal, and neglect to instantly transmit and upload the results electronically from the BVAS to the IREF, the first respondent stated in paragraph 55, Romans 7 and 10 as follows. Immediately after the election of 25th February 2023, polling unit results were uploaded and received by the e-transmission system whilst using the BVAS. There was a temporary failure of communication between the e-transmission system and the IREF portal for the presidential election. In this regard, the e-transmission system returned an HTTP 500 error, which is an application error such that transmitted results, though received on the in-transmission application hosted on the AWS, the in-transmission could not organize and push the results instantly to the presidential module on the RF portal because it could not map the result uploaded for the presidential election to any state. The first respondent pleads and shall rely on the AWS CrowdTrail logs indicating patches deployed to fix the error, technical glitch on the election day. Upon resolution of the HTTP 500 error, the results which were delayed in the e-transmission system were eventually organized and pushed to the IRF portal. The results are available as generated in their original form from the polling unit using the BVAS. The first respondent stated that the technical glitch did not ensure election. However, in